Lights are on. We're streaming to YouTube. We're ready when you are, Mayor McClure.
Okay. I'll call this City Council Board of Adjustment Appeal hearing to order. It's Monday, January 5th at 5:30 p.m. Deputy Chief, would you please lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. Ms. McClure, would you please call the roll?
Roll call for tonight's appeal hearing. Draper.
Here.
Osenga. Here. Kreitz. Absent. Calhoun. Here. Barnwell. Here. Warner.
Here.
And Mayor McClure.
Here.
You have a quorum.
Okay, thank you. So what we have tonight, we're sitting up here as a Board of Adjustment. There have been appeals to Planning and Zoning Commission's Resolution 2025-035. I'm going to just name the appellants and the appellees, and then we'll talk a bit about procedure. The appellants are Sarah Tougas, Annette Reese, Nathan Smith, and a group of Moriarty, Mica, VanBuskirk, and Katie Cornwell. So there are four sets to speak tonight. And then the appellees are, number one, the Planning and Zoning Commission via the Community Development Department, and Randy Wells. Does anybody have any questions about how the procedure will work, first of all? Basically, we will start with the first on the list, Sarah Tougas. Each appellant has 10 minutes, and each appellee has up to 10 minutes. But as you all know, you've seen this, the people involved, you can divide it up as you wish, or save time for rebuttals and such things. And so, are there any questions from any of the parties involved or council before we start?
I think we have concluded we want to save time for rebuttal, right?
So when your time comes or whatever, you can just tell us at that time how you want to do it. Is that okay? Okay. This is on YouTube, so this will be documented. At the end of the rebuttals, we will be moving to go into executive session to make some determinations. Those can't be finalized until another meeting where it's all written and we vote on something, so there will be a bit of a lag, but we'll come out and make some statement at the end of that time. So, council ready? We could just begin. I will just start with Sarah Tougas, and the clerk will be keeping track of the time, and if you have other people speaking with you or however, when you come up, it would be good just to let us know if you have an alternative plan. Maya?
When you said you couldn't vote on it until you've written a statement and then you would vote on it, would that be at a separate meeting or?
This is what I've been told. No, I think it will put it on like a council meeting once it's been written.
Thank you.
Yeah, it has to be formally in public. Okay,
There's a lot of people know.
yeah, it's just, YouTube. Okay.
Do I start?
I guess we should have, for the record, your name,
Okay.
even though I've already said, and then when you start, the clerk will start the timer for your 10 minutes. Does that sound right?
Can I ask you guys questions while I'm speaking? Can I ask you guys questions while I'm speaking?
This I would check with the attorney. That's not generally done.
I mean, like, can you hear me, or like a rhetorical question?
Like if they read all of our appeals, just to make sure everybody read our appeals.
Oh, I mean, I don't see that that's inappropriate. They can choose to answer or not, I guess, but
Okay.
if it's in the interest of just knowing that you don't have to restate your appeal, I think that's a reasonable
That's, okay.
question.
All right.
Okay, thank you.
So, Chris, I will start.
Okay. 10-minute timer is good.
My name is Sarah Tougas, and I live inside the city limits. Unfortunately, due to me being remote, I was unable to attend the December 2nd meeting. Can I get a show of hands of everybody who read our appeals? Thank you. I I am here formally to appeal the Planning and Zoning Commission's approval of Resolution 2025-035. Based on the location of the proposed drive-through and the extreme risks it poses to public health, safety, and general welfare. The approval also results in undue traffic congestion and relies on inaccurate and incomplete application materials. I have pursued this appeal only because myself and many other community members and roadway users are deeply alarmed by the lack of attention given to the safety at this intersection. My sole purpose is protecting the people who must use this intersection every day. The approval has caused a direct personal impact on me and my family. My family owns and operates a business at 1106 Port Avenue. Our family employs vendors, customers, and neighboring businesses rely daily on Port Avenue and the Seward Highway for access. We regularly operate heavy trucks and tractor trailers at this location and know this intersection extremely well. Every neighboring business I have spoken with shares these same safety concerns. Many neighbors initially intended to pursue appeals, but I informed them that I would take on the responsibility for handling an appeal. I asked the board to find that Planning and Zoning failed to properly determine compliance with the City Code 15.10.510 and 15.10.320, specifically the requirements to protect the public health and safety and welfare and to prevent undue traffic congestion. At the December 2nd Planning and Zoning hearing, commissioners were instructed by Community Development to consider only technical facts and were repeatedly led to believe approval was mandatory. Commissioners were told, using a McDonald's drive-through analogy, that even if they believed a drive-through was unsafe or inappropriate, they could not deny the permit because the underlying use was allowed. See pages 7 through 10 of the written transcript, or minutes 17 seconds through 20 minutes and 53 seconds of the YouTube recording. That guidance improperly narrowed the commissioner's role and directly conflicted with the code's requirement to independently evaluate public safety impacts. Public testimony was dismissed as opinion and treated as irrelevant. That is legal error. Public testimony and commissioner judgment are not optional. They are essential to the conditional use permit process. The KPB and city's partner 2025 Safe Streets and Roads for All Comprehensive Safety Action Plan identifies that the Seward Highway and Port Avenue intersection as the highest priority safety concern in Seward, including pedestrian paths and merge lanes. Surely this Board of Adjustments and applicant can recognize this. Given that designation, I ask you, why would we approve an increase in turning movements at both the beginning and the end of the highway merge lane at this intersection? This decision endangers not only existing roadway users, but customers of the proposed drive-through the most. The property's access points are located in the worst possible positions with no valuable alternatives. Any vehicle entering or exit these locations creates a unsafe condition. Consider this image: a 120-foot, 138,000-pound truck hauling flammable liquid accelerating through a merge lane, trying to get up to speed with oncoming northbound traffic while shifting an 18-speed transmission while watching for distracted drivers exiting a drive-through across the bike path where pedestrians regularly travel. A T-bone collision here would almost certainly be fatal to the passenger vehicle. Alaska DOT data shows that between 2013 and 2023, 68% of tractor-trailer versus passenger vehicle crashes resulted in fatalities of the smaller vehicle. Separately and decisively, the application itself was flawed. The applicant relied on an old Legan Associates survey for his on-site plan. The applicant then manually alternated the survey to accept a one-way traffic pattern exiting onto the Seward Highway using an exit that is an encroachment onto the highway. The applicant is unsure if he can legally use his driveway. Per Alaska State Statute 17 AAC 10.020 and AS 19.25.200, these regulations require that any driveway construction within a state highway right-of-way be evaluated for public safety and compatibility with existing traffic patterns, not impair or endanger highway infrastructure, including drainage, signage, and traffic control devices, and be subject to revocation or modification if the driveway is found to pose an unwarranted safety hazard to the public. The property owner does not hold the valid driveway permit authorizing access to the Seward Highway. This long-standing issue has historically deterred buyers from this property, and working with DOT was raised during the Planning and Zoning hearing, then ignored. Coordination with DOT is not optional. It is a required business practice for the public safety. My own family has a DOT driveway permit and has complied with DOT requirements for over 35 years. An application based on illegal or unauthorized access is inaccurate and incomplete. On that basis alone, the CUP should have been denied. Taken together, these issues demonstrate clear failures to meet the requirements of City Code. This appeal is grounded in fact law in the city's own safety planning documents. I respectfully ask this Board of Adjustments to apply the code as written, weigh the evidence fairly, and place the safety of our workers, residents, customers, and visitors at the center of your decision. Thank you for your time and consideration.
Thank you, sir. The second on the list is Annette Reese. Annette?
My name is Annette Reese, and I live outside of the city limits, but Seward is my town. Been here a long time. I rewrote my letter as appeal many times. Couldn't quite get what I thought I wanted to say. And then I read the letter that came out, or the statement that came out Friday from the city saying, wanted to know if we had room to standing to be able to appeal. And I am offended in that, to be absolutely honest, because I feel that we were given the right to appeal. But it was said, no, we don't have standing for it. The other thing is, when I read the 9-page report, I felt like I had tape put across my mouth. Not right. So I started questioning, what's going on here? In the very beginning at the planning and zoning, we were narrowly told that the only thing we could speak to or that was going to be judged on was the cut being granted, that it had met everything possible to be granted. As I was listening, as Sarah had so wonderfully said, she pointed out there's things that were inaccurate. I mean, I'm not an attorney and I'm not a governing person, but I could tell that there was things that were not accurate. Do we have to just take the applicant's word for it that something is right just because they said it? No, there needed to be proof. There needed to be proof of the things that was said. It's not your position to prove it, or the planning and zoning to prove it. It's the applicant's purpose to provide the proof of what he said. That was one of the things that was in the was written about the 9-page report, that we can't expect a small business to provide proof. I believe we do. I believe we need to. That's part of it. Like the documentation of saying that it had a permit for the highway. That needs to be, there's documentation for that. There was not. I'm quite concerned with the location of the business and how it affects our community. And I want all this to be on record, that if there is trouble, if it's granted, and there's trouble here because of it, you've already been noted that there is a problem here. There is a traffic problem here. Thank you for your time, and I appreciate all of you very much. Thank you.
Thank you, Annette. Okay, the next one is Nathan Smith. Nathan? Take a moment to get out of there and come up.
Nathan Smith, outside city limits. This is the first time I actually sat here and wrote one and not just kind of spoke my feelings, but I had to do some serious research, especially after Dan's report there. Members of the council, I'm speaking today as a business manager who employees rely on the daily Port Avenue and Seward Highway corridor adjacent bike path to get to and from work. I am the manager of Puffin Charters, which employs 10 people, serves up to 50 guests per day during the peak season, and I also represent Seward Hospitality Group, which employs approximately 40 workers across the 6 restaurants. many whom regularly commute by bicycle or scooter using the adjacent path. We provide them with that transportation. This appeal is not based on opposition to lawful business. It is based on my responsibility to raise foreseeable safety concerns affecting employees under my supervision. Community development has characterized this appeal as presenting generalized concerns shared by the public at large. That characterization does not accurately reflect our position or our relationship to this location. Our employees are not occasional users of this corridor. They are required, as a condition of appointment, to traverse this intersection and bike path repeatedly in all conditions, including winter weather. This creates a direct, tangible, and particularized exposure risk that is fundamentally different from general public use. As a manager, I'm responsible for workplace safety. When an approval decision foreseeably increases traffic conflicts in an access route employees must use, that impact is neither abstract nor speculative. It is operational and immediate. The Planning and Zoning Commission review focused primarily on whether the site had sufficient internal space to accommodate proposed use. What was not evaluated was the safety impact to the adjacent state-owned roadway or the designated bike path used daily by workers. State law recognizes that activities affecting DOT right-of-way and highway access require review to prevent hazardous conditions. That framework in existence as today protect exactly that type of roadway users and workers affected here. I want to be clear about what I am and what I am not asking the city to do here. I'm not asking the city to enforce DOT regulations or assume DOT's authority. I'm asking the city not to rely on findings of public safety without ensuring that required safety review occurs. Once a city is on notice of potential hazards, particularly those affecting employees and vulnerable users, it has a duty to evaluate those hazards before finalizing approval. Community development has suggested that these concerns fall out the city's responsibility because the roadway is state-owned. Alaska case law has repeatedly rejected that not our job defense. Lost my place. Courts have held that municipalities may not approve development while disclaiming responsibility for foreseeable safety risks when its own approval decision intensifies use at the known conflict point. Without confirmation of DOT review or permitting of the access points, the city has no evidentiary basis to determine whether existing hazards remain unresolved or whether the additional public safety hazards have been created. I want to state this clearly and respectfully for the record. If an accident occurs involving an employee or a bicycle at this location in the future, the question will not be whether the city had direct authority over the highway. The question will be whether the city had notice of foreseeable risk and chose not to evaluate it before approving expanded use. Today, the city has that notice. Concerns regarding heavy vehicle merge conflicts, winter acceleration limitations, and increased vehicle crossings of a bike path used by workers are now part of the record. Reconsideration does not delay safety. It demonstrates diligence. Proceeding without evaluation shifts risk away from the applicant and onto employees, roadway users, and ultimately the city itself. I'm requesting reconsideration so that the offset safety impacts can be evaluated and DOT consultation can occur before findings of the public safety are relied upon. That approach protects workers, protects the public, and it protects the city. Reconsideration today ensures that if an accident happens tomorrow, the record reflects that the city acted responsibly once concerns were raised. Thank you.
Thank you, Nathan. And the last is the group of Moriarty, Mica, VanBuskirk, and Katie Cornwell. And you guys, we have 3 chairs up here if you want to all 3 come. And I guess as you speak, you should state your names just for the record.
I'm Mica VanBuskirk, and I live inside Seward City limits. I am an aggrieved person under Seward City Code because I live in an adjoining neighborhood and must travel through the intersection next to this approved drive-through business multiple times a day to get to and from work. My exposure to the impacts of this approval is frequent and unavoidable, and greater than that of the general public. I also regularly walk, bike, and run the bike path directly in front of the site. This is already a known hazardous intersection, and the approval increases vehicle movements and conflicts the exact location where pedestrians and cyclists interact with site access. These impacts directly affect my personal safety in a way that is distinct from occasional roadway users, which is why I have standing to appeal. My primary reason for this appeal is that the Planning and Zoning's approval of the drive-through component was based, at least in part, on materially false and misleading information provided by the applicant during the public hearing. During the meeting at which the drive-through window conditional use permit was approved, multiple members of the public raised concerns regarding the presence of minors in vehicles during cannabis purchases. In response to that testimony, the applicant stated on the record that, quote, nobody, when purchasing cannabis products out of the drive-through window, nobody in the vehicle can be under the age of 21. That's from the meeting transcript. That statement is factually incorrect and directly contradicts the applicable AMCO regulations. According to these regulations, children under the age of 7 may legally be present in the vehicle during a drive-through cannabis transaction. The applicant's statement therefore materially misstated the regulatory framework governing the operation of a cannabis drive-through. In addition, the applicant misled the commission regarding how transactions may occur at the drive-through window. During deliberations, the applicant represented the drive-through operations would function similarly as a pharmacy, implying that orders must be placed in advance and the customers could not place orders at the window. While AMCO regulations restrict external signage and menu posting, they do not require that orders be placed in advance, nor do they prohibit customers from placing orders at the drive-through window. By affirming the pharmacy-style characterization, the applicant again materially narrowed the scope of activity that the commission believed that it was approving. These misrepresentations directly affected the commission's understanding of the intensity, duration, and behavior associated with drive-through transactions. Drive-through ordering at the window can increase vehicle dwell times, driver distraction, and queuing, particularly when customers are making selections or asking questions. These effects are especially relevant at this site, which include a known hazardous intersection and a heavily used pedestrian and bicycle corridor. The presence of minors in vehicles further compounds these safety concerns. Had the commission been accurately informed regarding both of the presence of minors and the permissibility of ordering at the menu, it may have evaluated the proposal differently, including the consideration of additional conditions, age limitations, traffic controls, and whether a drive-through component was appropriate at this location at all. The approval was therefore based on incomplete and inaccurate understanding of the operational realities. Quasi-judicial land use decisions must be based on accurate and complete information. When a decision-making body relies on materially false or misleading statements regarding regulatory compliance and operations, the resulting approval is procedurally flawed. This appeal is not solely about a drive-through window or a single permit decision. It reflects a broader and deeply concerning pattern in which the framework of decision-making for cannabis-related approvals in Seward has been repeatedly narrowed in ways that limit public input and constrain the deliberative role of planning and zoning and the City Council. This pattern first became apparent during the January 22nd City Council meeting when the Council first approved the Port Avenue Tufted Puffin on-site consumption endorsement, the first of its kind in Seward. At that meeting, the Council was led to understand that the approval was largely a matter of business compliance. The magnitude and novelty of authorizing on-site cannabis consumption in the community for the first time were not fully explained, debated, and the approval was granted after limited public comment and minimal deliberation. It was not until the Alaska Marijuana Control Office, AMCO, meeting the following week that the full scope and implications of this approval became clear. During that meeting, AMCO commissioners discussed the volume of public concern expressed through written testimony about this application and emphasized that endorsements of this nature are typically expected to involve meaningful local policy development and public debate. One AMCO commissioner specifically noted that it was unfortunate that the city had not exercised the broad authority afforded to local governments to regulate such activities. The expectation from AMCO was clear. Controversial new endorsements should be accompanied by local discussion, public hearings, and deliberate policy choices. Despite this, the same constricted approach to decision-making has continued Planning and Zoning has since held multiple public meetings, received extensive public input regarding cannabis-related land uses, including drive-through operations. Commissioners developed and discussed potential code changes that would reflect community values and address identified safety and compatibility concerns. However, these recommendations have not yet been considered by City Council. At the December 2nd meeting, commissioners were explicitly instructed to limit their review to whether a drive-through window should be approved, quote, like McDonald's, without considering the nature of the product being sold. Multiple commissioners expressed frustration with this artificially narrowed scope, noting that it disregarded months of public hearings, work sessions, and policy discussion. As one commissioner stated on the record, the commissioner was placed in the untenable position of being asked to approve a permit while being prevented from applying the very policy solutions it had developed through their public process. Together, these actions reflect a systemic issue. Decisions involving controlled substances are being segmented into narrowly framed approvals that minimize public debate and limit the ability of decision makers to consider cumulative impact, community values, and long-term policy implications. This approach undermines public trust and weakens the legitimacy of quasi-judicial decisions and conflicts with both the intent of local planning processes and the discretion expressly granted to municipalities under state law. For these reasons, this appeal should be viewed not only as a challenge to a specific approval, but a request for the city to restore transparency, full public participation, and a meaningful deliberation to its decision-making process. Remanding or reconsidering this approval would provide an opportunity to correct these procedural deficiencies, ensure decisions are based on accurate information, and allow elected and appointed officials to exercise their full authority.
Let me just interrupt for just a second. I'm assuming you're going over your 10 minutes?
No, started at 50.
Okay, go ahead.
I'm saying most of it. So for brevity, I'm just going to repeat when it comes to being a grieved person, everything that Mica said applies to her also applies to me. So I'm going to skip that piece. I want to start by I'm Katie Cornwell. I want to start by acknowledging something important. Every decision this council makes is guided by a commitment to public health and public safety. I'm not here to question anyone's intention. I'm here because that shared value gives you an opportunity to reconsider this decision in a way that strengthens both safety and public trust. This issue isn't about whether cannabis exists in Seward. It already does. The question before you is about how it is accessed. Specifically, whether we introduce a high-risk access model when a safer alternative already exists. We have been here before as a country. Before open container laws, people routinely drank while driving, believing it was manageable and not especially dangerous. Enforcement lagged behind behavior, and the results were devastating. At its peak, alcohol was involved in nearly 60% of traffic deaths in the United States. We didn't act until harm was visible. Prevention means acting earlier. It is also important to recognize that not all access models carry the same risk. On-site, walk-in purchases include natural protective barriers, separation from driving, time, visibility, and face-to-face interaction. Those are safeguards. A drive-through removes them. It collapses purchase and driving into one continuous act, normalizing use while driving, and relies entirely on individual judgment at the exact moment when judgment may be compromised. From a traffic safety standpoint, this matters. Traffic conflict theory shows that the more points where vehicles queue, turn, merge, and re-enter traffic, the higher the likelihood of crashes. Drive-through lanes add conflict points and change traffic patterns, increasing opportunities for error even before impairment is considered. Council is not expected to eliminate all risk, but when credible concerns arise and when safer alternatives already exist, approving a higher risk option is not a necessity, it is a choice. When council is presented with credible information, the decision will likely increase impaired driving risk, crashes and injuries. The responsibility is not to ask whether harm is guaranteed. The responsibility is to ask whether harm is avoidable. Choosing a safer option when it exists is not anti-business or anti-progress. It is good stewardship of community well-being. I urge you to apply that principle here and to align your decision with the responsibility you hold to prevent avoidable harm when safer alternatives are available. I'm asking you to pause and reconsider this approval, not to prohibit. Thank you for your time.
So, I'll just say, my name's Moriarty. I live outside city limits, but I work inside city limits for the last, since '98. Okay, so you had a total, all of you have a total of 40 minutes, and if you don't choose to use rebuttal time, you could, I believe, continue on if the clerk keeps track of the time. Do you know how much elapsed time has happened?
So Sarah Tougas has 4.5 minutes time remaining. Annette Reese has 6 minutes and 40 seconds time remaining. Nate Smith has 5 minutes and 5 seconds time remaining, and they used their full 10 minutes just
Okay.
now.
So there's about 15 minutes left. You may want to save some of it, let me just say, after the appellees speak, you may want to say something after that too. But we have up to 40 minutes, so if you want to take a moment and kind of decide how you want to use this, I'm seeing hands, so I think that would be acceptable because you get the 40 minutes.
Yeah, I'd say we
Give up my time.
This isn't being counted.
We definitely want to reserve time for rebuttal.
You're done?
I'll just finish my paragraph, because Maya was going to wait for rebuttal anyway. She doesn't
Okay,
have a speech.
okay, and then we'll see what's left, okay?
Okay. I'm asking you to pause and reconsider this approval, not to prohibit cannabis, not to reverse progress, but to align access with your stated priority of protecting public health and safety and to avoid a preventable increase in harm. That was it. Thank you for your time and your
Okay, thank you.
I just have 1 minute, less than a minute. As you can see, this place is packed, and so I didn't even read the rebuttal from planning and zoning or community development until today. So I just want you to know that even though there are only 4 people that have filed appeals, as Sarah said, you know, we represent so many other people. So if you really wanted everybody to appeal, not all of them can afford the $354 or whatever it was. And a lot of us have talked to AMCO. AMCO delegates to local governments to develop ordinances and codes that protect the public. They pass the buck to you. And it's not the other way around. Every time I've talked to AMCO, they say that it's up to the local government to develop ordinances, regulations, and policies. And so when they are surprised at a hearing that no one has objected to anything, it's because the public doesn't know what the procedures are. So we are asking that you take a strong consideration of all the statements that have been made, and if you haven't read the complete appeals, I know there's a lot of information, I ask that you do that, because everyone's spent a lot of time researching, talking to AMCO, looking at the codes. So we just hope that you take just as much time to make your decision. Thank you.
Okay, thank you. So let me double check, I believe probably with the attorney, it would be okay for appellants to come back and use up some of their time now, or should they wait?
I think they have the latitude to do that if somebody wants to speak now.
Because it's 40 minutes total that you have, but that would use up rebuttal time.
Right.
So, okay, so I will ask if any of the others would like to say anything now. Give you a second to think about it. Okay. Then I will close this portion, but then the time remaining is on record, the clerk has. So after the next set, if there's rebuttal, we can use that time up, okay? Okay, so next we have this is a word I've not seen before, appellees arguments. And there's a 20-minute maximum on this because there are 2 presenters. And so the first presenter here is from the Planning and Zoning Commission, via the community development, and I believe that will be Danny
And Courtney.
and Courtney, okay? And you'll have 10 minutes to,
The applicant has given us his 10 minutes to speak. We won't use all 20 minutes, so if he changes his mind after we're done, there will be additional time. Good evening, Mayor and council members. For the record, my name is Daniel Munich, Director of Community Development, appearing on behalf of the Planning and Zoning Commission, and joining me from our office is the City Planner, Courtney Bringhurst. Tonight, council is acting as the Board of Adjustment. Your role is to determine whether the commission applied the correct legal standards and whether its decision is supported by the evidence in the record. Council is not asked to reweigh evidence or substitute its judgment for that of the commission. Staff's role here tonight is to explain the record, clarify the applicable standards, and defend the commission's decision approving Resolution 2025-035. Before turning to the merits of the appeal, staff does believe there is a threshold issue worth noting, and that is of standing. Under Seward City Code, appeals may be filed only by persons who are aggrieved by a decision. That term has legal meaning and requires a showing of a direct, tangible, and personal impact caused by the decision, not a generalized concern, policy disagreement, or opposition to a lawful use. Based on the record, staff does not believe the appellants have demonstrated standing under the code. That said, if council chooses to proceed to the merits, Courtney will walk through how the commission satisfies each of the conditional use permit review criteria.
So the following are the 5 review criteria that the commission is required to review and confirm that the use is consistent with. Review criteria number 1. The use is consistent with the purpose of the Planning and Land Use Regulations chapter in the zoning district. The proposed drive-through is located within an auto commercial zoning district. Retail marijuana establishments are permitted outright in the zoning district. Consequently, the conditional use permit applies only to the drive-through component. The commission correctly found that the drive-through is consistent with the purpose of the auto commercial zoning district, which is intended to accommodate highway-oriented commercial activities that generate traffic and parking demand. The commission also determined the consistency of the proposed use with the purpose of the Planning and Land Use Regulations within City Code. The appeals argued that the proposed use conflicts with one of the chapter's purposes, which is to prevent undue traffic congestion. Under zoning law and land use law, this language does not require the city to eliminate traffic or prevent all congestion. Rather, it directs the city to ensure that development-related traffic impacts remain reasonable, safe, and proportional to existing infrastructure. Accordingly, the Commission's review properly focused on whether the existing roadway and site design are adequate to accommodate the incremental traffic associated with the proposed drive-through. Arguments raised in the appeals suggesting that the drive-through conflicts with zoning policy reflect disagreement with how marijuana uses are currently regulated within code. Public comments advocating for additional regulation of marijuana establishments raise legislative issues beyond the scope of a quasi-judicial CUP review. In a quasi-judicial proceeding, the Commission and the public are bound by the code as it is currently written. The proposed drive-through is allowed under the land use table and code and is consistent with the Planning and Land Use chapter as well as the zoning district. Review criterion number 2. The value of adjoining property will not be significantly impaired. In making this finding, the Commission considered the site's design, operation, and surrounding land use context. Traffic volumes associated with the drive-through are not expected to exceed those typical of the surrounding commercial and industrial uses. Noise impacts are minimal as the drive-through does not utilize ordering speakers. No new lighting impacts will occur as there are no menu boards, and business hours will remain unchanged. Vehicle stacking has been adequately addressed through on-site queuing. Finally, the site is surrounded by public rights-of-way on all sides except for one parcel to the east, which is a former Alaska Railroad right-of-way and primarily vacant except for a small portion of land that contains telecommunications infrastructure. Given the auto commercial zoning designation and the existing mix of commercial and industrial uses in the area, the Commission reasonably concluded that the drive-through is compatible with the surrounding properties and will not significantly impair adjoining property values. Review criterion number 3. The proposed use is in harmony with the comprehensive plan. The comprehensive plan supports small business development in appropriate commercial areas, and the proposed drive-through is consistent with the plan's broader economic development goals. The appeals and supplemental materials cite a limited number of responses from the comprehensive plan survey expressing opposition to marijuana establishments. While community surveys provide useful context during legislative planning processes, they do not constitute adopted policy and do not override the zoning code or comprehensive plan currently in effect. A small number of survey responses does not represent the community as a whole, and generalized expressions of preference regarding marijuana regulation raise legislative issues beyond the scope of this quasi-judicial appeal. Review criterion number 4. Adequacy of public services and facilities to serve the proposed use. As part of the standard conditional use permit process, the application was reviewed by city departments, including Public Works, Police, and Fire. No traffic, access, or public safety concerns were identified by those departments during their review. The Commission is entitled to rely on the expertise of city departments in evaluating public safety and service adequacy. Traffic impacts associated with adding a drive-through can vary widely depending on operational characteristics, service model, and site design. When evaluating the potential traffic impacts of a drive-through window, the primary considerations include the adequacy of on-site queuing and circulation, whether the proposal introduces new ingress or egress, or relies on existing access, and the context of surrounding land use. Consistent with that understanding, the Commission considered owner-provided estimates and general trip generation ranges to evaluate whether anticipated activity levels could be safely managed on-site. The approved site plan identifies approximately 80 feet of queue space, accommodating 4 vehicles in line and 1 vehicle at the service window. Transactions will be pre-ordered and prepaid, limiting service time to identification, verification, and product pickup. Expected services times are short, resulting in minimal queuing. Even under conservative assumptions, the available queuing capacity exceeds anticipated demand and prevents vehicles from encroaching on the public right-of-way. The appellant's arguments assumes without evidence that the sale of coffee would transform this use into a high-volume, commuter-oriented drive-through similar to a standalone coffee kiosk or national quick-service restaurant. There is no support in the record for that assumption. The proposed drive-through remains accessory to an existing regulated marijuana retail operation with limited customer throughput, age-restricted access, and a fundamentally different market profile than typical morning commuter coffee traffic. Review criterion number 5. The proposed use will not be harmful to the public safety, health, or welfare. The safety concerns at the Port Avenue and Seward Highway intersection are long-standing, and as acknowledged in the appeals themselves, are primarily attributable to large tour buses, trucks hauling oversized boats, semi-trucks, and freight vehicles, including those carrying potentially hazardous materials. There is no evidence in the record that the proposed drive-through would materially exacerbate these conditions, particularly given that the anticipated drive-through traffic consists of small passenger vehicles rather than heavy or oversized commercial traffic. The 2025 Kenai Peninsula Borough Safe Streets and Roads for All Comprehensive Safety Action Plan does highlight the Port Avenue and Seward Highway intersection as an area of safety concern. However, the purpose of this Comprehensive Safety Action Plan is to identify system-level traffic challenges and recommend infrastructure and design solutions to be implemented by the DOT and city. These broader infrastructure solutions are beyond the scope of what can reasonably be required of a single small business owner through the CUP process. Restricting an otherwise code-compliant business through the CUP process is not a substitute for addressing broader system-level transportation issues. These improvements are appropriately addressed through transportation planning and engineering, not through denial of a conditional use permit. Appellants have also raised concerns regarding potential safety impacts to pedestrians and cyclists on the adjacent bike path. However, the Alaska Department of Transportation has already approved the 2 driveway access points serving the property. Vehicles will enter and exit the site across the bike path regardless of whether the drive-through window is implemented. The proposed drive-through does not introduce a new condition or conflict between vehicles and cyclists beyond what is already permitted and existing. The appeals identified potential safety concerns related to the manner in which products would be sold through the drive-through window. These concerns fall outside the scope of the Commission's authority and are not relevant to the land use compatibility analysis required for a conditional use permit. The Commission's role is to determine whether the proposed use is appropriate for the location based on the applicable review criteria, not to regulate or evaluate compliance with operational or industry-specific regulations. Regulatory oversight related to the sale of products through a drive-through window is the responsibility of the appropriate governing agencies. In this case, the Alcohol and Marijuana Control Office, AMCO, regulates how the business sells its products, just as the Health Department regulates food safety for fast food drive-through operations. The Commission may not deny a conditional use permit based on speculation regarding compliance with regulations enforced by other agencies. Ultimately, the appellants have not provided substantial evidence that the proposed drive-through will generate traffic volumes exceeding on-site capacity or materially worsen intersection operations and safety. Under established land use law, conjecture, extrapolation, and generalized opposition do not meet the evidentiary threshold required to overturn quasi-judicial approval.
And so in closing, Resolution 2025-035 demonstrates that the Planning and Zoning Commission applied the correct legal standards, made the findings required by the Seward City Code, and relied on the evidence in the record. Importantly, legislative draft concepts or discussions do not have legal effect. The Planning and Zoning Commission was required to apply the zoning code as it existed at the time of its decision. Pending, proposed, or previously discussed code amendments cannot be applied retroactively to a quasi-judicial application, because if they were, applicants could not reasonably rely on the code and land use decisions would become unpredictable. And so finally, I'd also like to add that this type of proceeding places our office in a position we don't necessarily enjoy. In any case where a commission decision is appealed, staff is required to take a position and defend the decision of the commission, and we take that responsibility seriously, and I hope we've shown that throughout this proceeding. When the commission is acting in its quasi-judicial capacity, we take a neutral stance unless directed otherwise by the city manager's office, and that neutrality allows us to assist applicants as they prepare their case before the commission, support the commission as it works through its decision-making process, and talk with members of the public on all sides of an issue about how best to share their input. Our office has a bit more flexibility when the commission is addressing legislative matters, but even then we try hard not to put our finger on the scale too much. Of course, we form our own professional opinions as we do much of the background research for the commission, and those views may come through during work sessions, but we make a conscious effort to remain as neutral as possible to allow the commission to reach its own conclusions, because at the end of the day, staff is not elected or appointed to make policy decisions or change the code. And so I like to lead our office in that way so that when legislative topics come up, like marijuana land use, before the commission, community members from all perspectives feel comfortable coming to us to talk through their concerns. And we want to continue engaging those conversations with community members on all sides of an issue, as we've done with many people in this room tonight. That kind of open, balanced dialogue helps our office better understand where the public is coming from on all issues, and in turn better serve as the technical advisors to the commission that the code instructs us to be. So for that reason, I'd like to come full circle back to the issue of standing, as staff believes it is important for council to address this issue, at least at some point in the future. Clear guidance on when an appeal meets the requirements of an agreed party helps protect the integrity of the quasi-judicial process. My main concern in this proceeding is that a legislative battle is being waged in a quasi-judicial arena, which raises concerns about the precedent it could set, namely that future appeals may be filed simply because someone disagrees with what is currently allowed in code. Without that clarity, staff could increasingly be placed in the position of taking sides in appeals driven by general disagreement, which is not the role our office is intended to play. If council chooses to address this issue of standing through this decision or at a later time through code clarification, staff does believe it would be beneficial for the community to understand how council interprets that appeal requirement. And so for all the reasons stated tonight and in our written submission, staff respectfully requests that the council uphold the Planning and Zoning Commission's decision. And thank you. We're happy to answer any questions or leave time for the applicant if you should choose to do so.
Anything from you guys? Okay, thank you. Randy, do you want to speak?
I believe community development said everything that there was to say.
Okay.
Thank you for the opportunity.
Are there, I've not opened it for questions yet, but are there questions for administration? Oh, go ahead, Councilmember Barnwell.
I always have questions. I don't know if you can answer this, Danny, but it's probably hard for you to answer this. I don't know. I'll just put this out there. We see that there's opposition to this decision, and it's a multifaceted, it's a deeper problem than just this drive-through. Where did the city, in your opinion, go wrong? And don't be afraid to critique us as a council. Where did we go wrong in this process where we don't, I kind of agree, I actually do agree. We haven't had a lot of deliberations on this topic. We haven't really dove in.
I don't know that this is pertinent to what we're discussing right now. I know it's a good question.
Okay.
But we're really just listening to the appeal and the appellees. So I think this is a topic that we can ask them at a future meeting. We have to stay on the topic of this particular thing. If you have a question about what they have stated in their statement, that would be appropriate. But otherwise, we can't get into anything like that, I don't believe.
Okay, I'll just retort that just for a little bit. I'll let it go. I do think it's kind of appropriate because we're a bit lost on the council and I think in a lot of the public about how to. It seems like we're stuck, and I'll just leave it like that.
Okay, I think you better because we will be discussing in the future. We have a discussion about this whole topic that's not the topic of tonight, but I don't think that this is the appropriate time.
Yeah, okay.
Because we could go down that rabbit hole very deeply.
Yeah.
I'm afraid.
Yeah. I got it.
Are there any questions pertinent to? Okay, thank you. And now we can go to the rebuttal from the appellants. And individually we could, okay, I see that Sarah Tougas wants to use some of her time, and we know how much time's available.
So after the donation, your remaining time is 2 minutes and 45 seconds.
Okay. And then, we'll get each one that has time.
I just want to note, there seems to be a disconnect on what the state and the city thinks about the driveways approval. The city is the jurisdiction of Port Avenue, and the state is the jurisdiction of the highway. In the rebuttal, they say that the state has approved both driveways. DOT actually was mentioned. They do want input from this. So there just seems to be a disconnect on what the city thinks possibly and possibly what the state thinks. So thank you.
Oh, okay, thank you. Come on up. And how much time does Nate have?
Nate Smith has 5 minutes and 5 seconds remaining.
Okay.
Just to add to the last part of what she was saying there is we have email confirmation from DOT that says there is no permit for that driveway in the name for that business or the person owning it. First thing I just want to rebuttal back to is that the community and Dan says that aggrieved, that he doesn't find us aggrieved. And my answer to that is my employees are required as a condition of employment. And they have to use that quarter and bike path daily to get to work. It is not an optional or occasional use. It is repeated, foreseeable exposure tied directly to management responsibles for workplace safety. So therefore, I think his aggrievement is wrong. Also in his rebuttal that he put on there, he put that the city departments did not raise any objections. Well, the city did not have DOT listed on there for the DOT roadway. So the city's portion of it said, we don't have any problems here. But then the one part that they know that the state regulates, they didn't ask. And that is part of his site plan to enter and then to exit. And so if you are approving something with a site plan that has an entry and exit point, and this point that we now know that DOT has not had application or even an entry as of today, even at 3 o'clock. They said there was no application for, so it can't, that plan can't be even there. And I know in a lot of other instances, DOT would be contacted in that. And then for my other one, it isn't your guys' responsibility to obtain that permit, it's his. When he bought the property, that is part of what you do. So his lack of knowledge, and we all know that, hey, I didn't see that stop sign, doesn't get you out of the ticket from the cop. Not knowing is not part of that process. And then, so, I just want to reiterate here, got 2 minutes left, the memo, this memo that I wrote in the appeal, the framing overlooks a critical fact in how he says that we're generalized in our standing. This is not optional use, it is repeated. Let's go down to the last one here. And also, on the last one, that I think was really big on with the city, the absence of objections from city departments doesn't mean that there are no evidence of hazards exist. It only reflects that those specific concerns were not evaluated. Once raised on the record, the city has a duty to protect us. That's what you're here for. You're the last standing thing, and that's what we're all here to say. Because our conversations with DOT are going to say something way different, and I don't want to speak for them, and I don't want you to do their job. I want our government to do our job for us, and that's why I'm sitting here. So thank you.
Thank you, Nathan. Okay, of the appellants, that pretty much ties it up.
Is that all the time?
Well,
She's giving me her time.
yeah, Annette has how long?
6 minutes and 40
So
seconds
Annette,
for
if you
Annette.
want to,
I'm giving it to her.
and that should be acceptable?
Yeah, go ahead.
Go ahead.
Mine is brief. Maya Moriarty. I just wanted to raise a couple exceptions to planning and zoning's rebuttal. In the first paragraph, it says that the council does not reweigh evidence. That's the whole purpose of an appeal. When you do a lot of research online about code and appeals, one of the responsibilities that you could decide on is error correction. Was there an error in how the legal interpretation was applied? And so a lot of information has been given to you about that, whether traffic congestion is an issue or not, if safety was fully considered. And so I know that they have not really given a lot of evidence or credence to Commissioner Hubbard's alternate findings, but she did have some valid points in her alternate findings. Also in the December 2nd meeting, Planning and Zoning did not apply any safety or security measure conditions, even though they were in the Planning and Zoning agenda statement, and they were discussed but not voted on. And so I think that's what's confusing to the public. They mention it in the statement, they discuss it, and then nothing happens. So I think what we don't know that needs to happen is that someone has to make a motion saying, yes, we should require a one-way sign. Yes, we should require, whatever, and then they implement it. But nothing was implemented, even though in public comments and in the agenda statement that was created by Community Development, they did have some recommended conditions. So I do think it is your purpose as an appellant board to reweigh the evidence and possibly remand the decision back to Planning and Zoning.
Okay, thank you. Mica, you want to use up part of that group time?
Yes, please.
Okay.
I have just a couple comments regarding standing. I consulted with an attorney today, and the statement that I wrote was written by them about why we do have very specific standing in the situation. So that, and each one of us has been very careful to explain exactly why and how we do have standing. In terms of the comprehensive plan, that comprehensive plan, both the existing one and the future one, it's being drafted with incredible public input. I've never seen a research being done as well as they're doing this year. They're going to entities, they're interviewing people, there's multiple interviews. Both of these have been picked and chosen over which items are being pulled out. It could very easily be defended in the opposite way with statements from our comprehensive plan. So that is not a valid explanation. Finally, it is just plain and simple that lies were told and misrepresentations were given to the commission during the decision process. That and that alone is enough for you guys to remand this back. That has not been rebutted. That was not included in any of the rebutments because it is plain and simple. It's in the transcript. There was a flat-out lie stated, and then there was misrepresentation. A very important aspect of what the decision was made by these incredible volunteers that sat at the dais with incorrect, very important information. If you guys are able to remand this, postpone it, let it be reconsidered, because what Mr. Barnwell was just saying is very important, that this is a big issue for our community. We need more open discussion. We do not need to railroad a decision through before, I don't know if you guys can see how many people are in the hallway, but it's packed out there. Our community cares about this. We don't have to say no right now. We just have to say we're going to consider this. We're going to reconsider this based upon misrepresentation of the facts, and then we're going to open it up to public input on both sides and have a more healthy decision within our community for the public health and security of our entire community. Thank you.
Okay, thank you. All right, so we've heard from both sides, and I guess it's time for us to begin to consider the facts and discuss it. So at this point, I guess I need to move to go into executive session. Is this correct?
Yeah, that's correct.
Okay, so I'll move to go into executive session for the Board of Adjustment to deliberate and prepare findings of fact and conclusions of law with the municipal attorney. And there's a code for this, AS 44.62.310D1. And I'd ask for a second for that.
Second.
Okay, and it's been moved and seconded. We'll vote on going into executive session. You don't have to run off yet. We'll take a bit of a break, but let's vote on that.
Voting to go into executive session for the reasons stated. Warner?
Yes?
Barnwell?
Yes.
Osenga?
Yes.
Draper?
Yes.
Calhoun?
Yes.
And Mayor McClure?
Yes. And in this executive session, we'll have the council and our attorneys.
Yeah, I'll be there.
Sam, and that's it. We won't have the, so let's take a bit of a break. Do we need 5 minutes? Probably to get everybody, let's take a 5-minute break just to clear things, and then we'll come back and go into executive session. When we come out, I will gavel us back into the meeting, and we'll have a collective statement of some sort, okay? I don't know if it'll be the definitive, well, we'll see. I mean, this is new. We don't know what we'll come out with, but we will come up with something.
Yeah, that's what I was just going to suggest, since there are a number of people. I mean, one, there isn't really a time limit on the executive session, so we may be talking for a half hour or hour and a half.
We just don't know.
We don't know, and it may not be a decision verbally tonight. It may be to come back or work on written findings. So those of you planning your evening, I think that's the best we can do right now, but take that into consideration.
And we do have up to 30 days to actually come out with a written statement that we would vote on publicly. So there is a bit of time lag. So, this is like any other, like a jury decision or something. You never know what's going to happen when you go in and like that. And that was your question, Nathan, right?
Well, yeah, if we do choose to leave, will you turn it back on YouTube if we have it at home?
Oh,
if you do make a statement?
Yeah, we'll get the clerk back down here like we do with all executive sessions.
Okay.
It'll go back on, like in the interim, it'll say executive session now, and then it'll come back on, so it'll be there, whatever we say when we come back.
So the recommendation is for us to leave and then...
Oh, yeah, I wouldn't hang around because you can see it on YouTube and there's no real point because we don't know how long this will take.
Okay, that works. Thanks for your time.
Okay, so I'm going to gavel us out right now, and then I'll gavel us, then we'll go back into executive session at 6:40. We'll take a bit of a break.
Okay, we are back on the air. Ready when you are, Mayor McClure.
I'm going to call this session of the council back to order. It is 8:03. And I want to first of all thank members of the council and also our attorney for the hard work and discussion we've just had. Our statement is this right now. We have deliberated and have directed the city attorney to draft findings and conclusions consistent with Chapter 15.10.430 in the code. The code allows us 60 days from the appeal, and it is our decision to render a written decision and vote on January 6th. We're pretty optimistic. January 26th, I am so sorry. Also, the time for debate is closed, and it would be inappropriate for the public at this point to offer opinions and speak to council members just as it's been during the appeal until the final decision and voting is issued. And with that, I will adjourn the meeting at 8:04.